Are there any other votes? Announce the results.
Ayes 83, noes 29.
The bill is passed. Mr. Morelli.
Yes, sir. Before we take up the next bill, I want to inform members of the Codes Committee that Mr. Lenthal is ready for that meeting in the Speaker's Conference Room, Committee on Codes.
Codes Committee, Speaker's Conference Room. Clerk will read.
Assembly 6932A, Calendar 542, Ms. Weinstein. An act establishing the New York State Abandoned Property Neighborhood Relief Act of 2016.
An explanation is requested, Ms. Weinstein.
Yes, Mr. Speaker, as I think people have heard, zombies are on the rise in New York State. They are in cities large and small across New York State are facing the problem of vacant and abandoned residential properties that fall into disrepair. They are a blight on our neighborhoods. They are magnets for crime. They depress property values and harm surrounding communities. And
Mr. Morelli.
I'm sorry.
Why do you rise?
Yes, I apologize, Ms. Weinstein, for pardon me for the interruption, but we made a little error in our announcement. We need to have the ENCON committee meet first, environmental conservation, before codes. My apologies. We missed that one. So Mr. Engelbright is going to take members of the Environmental Conservation Committee. We'll follow that with codes. And Ms. Weinstein, again, I apologize.
ENCON, Speaker's Conference Room. Codes will follow. Mr. Engelbright is on his way. Excuse us, Ms. Weinstein, proceed.
So as we discussed in the prior bill, mortgage lenders across New York State have contributed to this problem of zombies. Banks frequently commence foreclosure actions and fail to pursue it. Homeowners are pushed out of their property because they are given the impression that they have to leave early in the foreclosure process. And delinquent mortgage residential properties that are vacant and abandoned fall into disrepair. One of the latest estimates is that there are over 16,000 such zombie properties in New York State. And they are very costly to local governments who are left having to secure and make them safe at taxpayer expense. In the prior year, we have imposed property maintenance requirements on lenders when they are successful in the foreclosure action. What we are doing now by this bill, the Abandoned Property Neighborhood Relief Act, is ensuring that homeowners are provided with early notice that they're legally entitled to remain in their homes until ordered by a court to leave. It will importantly require mortgagees and their loan services and agents to identify, secure, and importantly maintain vacant and abandoned properties much earlier in the mortgage delinquency timeline. The bill would also create a statewide registry of properties, a hotline for community residents to report the presence of those properties. The lenders would be required to notify the Attorney General when properties are 3 months delinquent. It would allow localities and the Attorney General to enforce the maintenance of property requirements. It would establish a fund for civil penalties for failure to maintain the properties, where they would be deposited once collected, and that fund would be available then for localities to make application for monies to help in enforcement. And it really complements the Department of Financial Services voluntary agreement with 11 of the banks and servicing agents to, in fact, inspect their properties. And it also is similar in its requirements for FHA or Freddie Mac properties, where the mortgagee loan servicers are required to maintain properties.
Mr. Goodell. Thank you, Mr. Speaker. Would the sponsor yield?
Will you yield?
Yes, happy to yield.
Sponsor yields.
Thank you, Ms. Weinstein. Under your bill, who pays for the cost of this maintenance pending a foreclosure action?
The under this bill, if the owner of the property that is not maintaining it and the mortgagee is coming in to maintain it, that's a cost that can be a reasonable cost that could be then transferred onto the property owner, the homeowner.
So under your bill, the bank may pay for the maintenance, but then the bank turns around and bills the homeowner, right? And adds the cost of this maintenance onto any mortgage foreclosure judgment?
It could be a cost that the bank could bring forward.
And if there's a deficiency
Not
judgment?
a requirement, but it could be.
And then if there's a deficiency judgment, the bank would have the right to pursue the homeowner and get an income execution and foreclose on other assets that they would have, just like any other lien holder?
There's nothing that expressly says, gives that authority, but there's nothing that precludes them from taking that action.
And under most mortgages, residential mortgages, of course, that's part of my business. I do a lot of real estate in the private sector. All those mortgages say that if a bank advances funds to maintain a property, not only is it added to the mortgage, but it's added to the principal of the mortgage, which means the homeowner is then charged interest. Is that your understanding as well?
I don't know what your contracts say, but if I would assume in some circumstances that would be the case.
Now, this bill allows a municipality, homeowners association, even a tenant that's living in the house to bring an action against the bank to force the bank to maintain the property, correct?
Yes.
And does this bill authorize any of those individuals, a tenant, for example, or a homeowners association or a municipality, does this bill authorize any of those entities to bring an action against the homeowner who's not maintaining their own house?
I'm sorry, could you...
Sure.
I'm sorry.
Is there anything in your bill that would authorize the municipality or homeowners association or a tenant to bring a lawsuit against the actual owner of the house for failure to maintain the house and seek an injunction directing the owner who owns the house to fix it?
No, but there is current law in communities throughout the state, building codes requirement of property maintenance that exists today that's unrelated to the foreclosure process.
This bill imposes a civil penalty of up to $1,000 a day if a bank doesn't maintain a property. Is there any existing law that you're aware of that imposes up to $1,000 a day civil penalty on the owner for failing to maintain their own property?
I am not really versed in the particulars of each of the localities' penalty structure, but certainly there can be violations, I know, for failure to maintain property issued by a municipality now.
But nothing in this bill dealing with zombie properties that is directed to the actual owner of the property to maintain the property. Am I correct? It's all directed at banks who don't own the property and not at the homeowner. Am I correct?
It's related to vacant and abandoned properties. As we talked about before, when you look at how long it takes to go through the process and how much of that length of time is extended by the banks, by the lenders,
But there's nothing directed toward the owner, is there, to maintain the property under this legislation?
No.
I understand it applies to vacant and abandoned properties, but there's nothing directed at the actual owner to maintain their own property, correct?
Not in this bill, but as I said, there are existing statutes in municipalities all over the
Now-
state requiring maintenance.
Now, you mentioned that this is aimed at properties that are vacant or abandoned, but it also includes properties that are inhabited, correct, by a tenant.
Yes, it can be.
And not only can the tenant now call up the bank and demand that the bank fix the house that the tenant's living in, but the tenant can actually sue the bank if the bank doesn't fix the house that the tenant's in, correct?
Unfortunately, can you just repeat the second half of it?
Sure. I mean, not only is the tenant allowed to stay in the house, of course, but the tenant can now sue the bank if the bank doesn't maintain the house, right, and collect damages against the bank.
We're talking about a tenant, not the owner.
Correct. The tenant in possession. That's correct.
Yes.
And they have the right to sue the bank if the bank doesn't maintain the house for the tenant.
No, they can report the property, and then the municipality can bring the action.
But they have a direct cause of action against the bank under this legislation, right? I mean, they're specifically named. I'm looking on page 3,
I
line
don't
50.
believe so. I think it's only the municipality and the AG's office.
Well, I'm looking at page 3. In addition to the authority granted to the Attorney General, any tenant in lawful possession can bring an action, shall have a right to enforce the obligations. So you have a tenant living in the house. It's not maintained to their standard. The bank's not getting payment from the owner. This bill doesn't impose any obligation on the owner to maintain it. The tenant calls the bank and says, fix this house up for me. And if the bank doesn't, the tenant can sue, right? That's what this language says. I'm looking at page 3, line 50.
Let me just catch up.
Is there anything in this bill that requires the tenant to make rent payments to the bank?
No.
Is there anything in this bill that gives the right for the bank to collect rent from the tenant?
From the tenant, not from the tenant, but from the mortgagor.
So we have a bill that says the bank can't collect rent from the tenant. Tenant has no legal obligation under this bill to pay rent to the bank, but the bank has an open-ended obligation to maintain the property to the tenant's satisfaction, and if he doesn't, the tenant can bring a lawsuit against the bank. Happy days if you're a tenant. Did I miss something in that?
I didn't know. I didn't hear that as a question.
My question is, isn't that true?
They're not collecting rent because they're collecting their mortgage. So, as we discussed before, there may be expenses that they incur that they may be able to make application to have, but their mortgage contract is not with necessarily the tenant that's there. You're talking about a tenant who's not an owner of the property.
Now, under your bill, if a bank doesn't maintain the property, they could be subject to a fine of $1,000 a day.
Correct.
If the bank does enter the property to make repairs, and it turns out the bank was mistaken, there's actually a tenant in there, then they're subject to punitive damages, correct?
No, I don't. Where do you get that?
The punitive damages clause is on page 3, line 42.
But if they're coming to make the repairs because it's abandoned and vacant, then it's a lawful entry. The punitive damages is if it's an unlawful and would only relate to trespass and unlawful entry, which wouldn't be happening if it's a vacant abandoned property.
It just puts the bank in kind of an interesting dilemma because they're subject to massive fines if they don't maintain it. But if they do enter and it turns out that there was a tenant and they entered to make repairs, then they could be subject to punitive damages on the flip side. So it's a very awkward situation. But let me move on, if I may. Have you done any evaluation on what impact these costs might have on mortgage availability, particularly to a working poor? I mean, there's nothing in this language, for example, that would prohibit the bank from adjusting income-to-debt ratios, right? Or debt-to-asset ratios, or credit score ratings, or anything like that for new mortgages?
No.
Is there anything in this legislation that requires the bank to foreclose on a mortgage?
No, but it would be in their interest to shorten the period of time that from the beginning of an action till its conclusion, as we've discussed, many of the issues that are under their control, to shorten the period of time that there might be a duty of maintenance, which doesn't begin till after there's been the 30 days of, 3 times of missed mortgage payments is when the duty to inspect would first occur. So the duty to maintain first would come after that. So while we don't, this bill would encourage a quicker action to
But a bank at any time can just release its mortgage lien, correct? And nothing that prevents a bank from just releasing the mortgage lien?
You mean in turning the property over to the municipality?
Well, just release the mortgage lien and just sue on the debt. They don't have to foreclose on a lien, right? I mean, there's nothing in this that prevents the bank from just releasing their lien and walking, correct?
Right. I mean, there's nothing in this bill that would prevent that from happening.
So let me just walk this through. You can go through the regular foreclosure process. It'll take the bank almost 3 years under current procedures. They incur the potential for all the costs of maintaining the property. They have to deal with tenants who are calling up and complaining that the property is not met to their satisfaction, but they have no ability to evict the tenant or collect the rent. And they face potential punitive damages and up to $1,000 a day civil fine. But with all this going on, couldn't the bank just bring a motion for summary judgment in lieu of a complaint under 3213 of the CPLR and get a judgment in about 45 days and forget about this entire process and then foreclose on the judgment? And if they foreclose on the judgment, am I right? There's no mandatory settlement,
Right.
no pretrial conferences. I mean, boom. Call the sheriff, arrange for the auction.
You know, that's been a question that I've had, is if it's truly vacant and abandoned, you can bypass the settlement conference process. You can move right away into the court for the foreclosure, and it would be a much shorter period of time. So I would agree that there exists in law a process to do a quicker process that might eliminate some of the need to maintain, which means that that property would be transferred, would be sold, and there would be a new owner in a faster situation. But the reality is that's not happening.
So what this bill does, if I understand it correctly, is it says to a bank, very glad you lent money to these folks, the homeowners. We understand they promised that they would maintain the property, right? It's on every mortgage document. They promised to maintain their property. They promised to pay you back your loan. That's why you made the loan in the first place. You, the bank, acted in good faith, and you made the loan. You, in good faith, the bank, accepted their promise that they would maintain the property and that they would pay you back. The homeowner then violates every promise he made. He violates the promise he'd paid the bank back, and all those other promises that I've now run out of time to list separately. But thank you very much for your comments. Thank you, Mr. Speaker.
Thank you, Mr. Goodell. Mr. Walter,
Thank you, Mr. Speaker. Would the sponsor yield for a couple
will
of
you
questions?
continue to yield? Yes, the sponsor yields.
Thank you, Ms. Weinstein. A couple of questions. After the mortgagor doesn't pay their payments for 3 months, and then the bank goes in, inspects the property, finds it abandoned. Their responsibility is to maintain the property going forward. If someone were injured on that property while being maintained, who would be liable in that situation?
It would depend on it. It would depend on the. I would think the owner of the property. You know, right now, to sort of respond a little bit to the question that was posed before the bell rang, the buzzer rang. You know, right now, almost all residential mortgage contracts contain the clause imposing a duty on a borrower not to commit waste, destroy, damage, or substantially change the property or let it deteriorate. And the contracts typically, currently, have language that permit the lender to inspect the property if it's vacant or abandoned or the loan's in default, and they permit the lender to take reasonable action to protect and preserve such vacant or abandoned property. So it's not such a new concept that we're adding here, especially under FHA insured loans. With loans in default for 45 days, there's a requirement that the mortgagee take reasonable steps to protect and preserve the vacant or abandoned property. So it's not a new concept that we're introducing. We're just expanding it to more properties. And any of the questions that you raise in terms of liability of someone doing the repairs would be no different than under if it was an FHA loan or if the mortgagee on their own action, not because of this legislation, but under the contract, their mortgage contract, that allowed them the authority to enter the property to make repairs, to preserve their interest if those repairs were to happen. So I don't see how any of the liability, there would be a liability issue that would arise out of this.
Well, I just think in this situation, the likelihood is that if they've abandoned the property, they haven't paid their mortgage in a number of months, they certainly haven't paid their homeowner's insurance, I would assume. It would be silly to pay your homeowner's insurance when you're not even paying the mortgage. But the liability upon the bank to go in and do those repairs, knowing that there is no insurance, basically, to back up any sort of liability claim, I think is a scary prospect for the bank in that situation. Just move on to another section of the bill, Section 1308. Now, it appears at first blush that you're giving the bank an opportunity to expedite the mortgage the foreclosure process in a situation where they can prove that it is abandoned and that they can do an order to show cause, bring it before the judge, and list all the reasons why they think it's abandoned, and have an expedited process to foreclosure. And I think the Attorney General had a bill similar that basically said the same thing. But I note the difference.
This is the Attorney General bill.
A previous version. A previous version of the Attorney General's bill had a distinction, though, and that I think you've got in here. You have that there still has to be a settlement conference in the expedited foreclosure matter. That didn't exist in the previous Attorney General's bill, but he is here in this one. Doesn't that automatically slow the entire process down once again and get us back into the same old situation where we're taking 900 days to foreclose on a property because 270 of those days are spent getting a settlement conference?
You know, I just have to, I do think we do provide a expedited process, and actually, as Mr. Goodell and I spoke, there actually is a process that lenders don't seem to avail themselves of now to be able to bring a more expedited procedure. You know, but again, you know, as the settlement conference preserves the due process protections that we've put in place. So we don't want to totally abandon all of that to deal with these zombie properties. You know, but again, if I refer to some of these delays that keep getting talked about, close to you know, let's say over 5 months of the delay is the failure of the lender to ask for judicial intervention after they've served the process. Just sitting around waiting for that to happen. We don't know why, and that's the average. So it could be a year, it could be 2 years, and we have the shadow docket of the process, the foreclosure process being started, but never availing themselves of the court process. And then, and again, as we talked about in the earlier bills, the delays of the settlement conferences are most often the delays, the requests for adjournment come out of the lender's failure to either have somebody there who can make a decision or to bring proper paperwork. And then one of the biggest delays is when the settlement conference ends to the entry of judgment of foreclosure and sale. It could be talking about almost a year to more than a year, and again, that's largely in the hands of the lenders. They may be waiting for property values to go up. They may be just having time backed up and not doing their paperwork, but you can't talk about the length of the process and put the blame, and without putting the blame squarely where it belongs, is on the lenders as the fees and interest keeps going up and up.
Okay. Thank you, Ms. Weinstein. On the bill.
Yes.
On the bill, sir.
You know, we have a tremendous opportunity here because zombie properties are a real problem. I've joined my colleague from Western New York and stood up on the front lawn of some of these homes that have been abandoned by the property owner, by the mortgagee, and are a problem in the community. But the issue here and the opportunity here is to create a process where we can get the bank in title of that property as quickly as possible and turn it around and not make it a zombie property anymore. Unfortunately, this is a missed opportunity because we're going to further delay the process with this bill. And we're going to create issues where there is no clear line of liability when we're maintaining the property. There are a tremendous number of properties that could be turned around in a heartbeat, but these conferences and regulations and all of this procedure to protect the interests of the homeowner, which I completely understand, shouldn't apply when that home has been abandoned, when there's no one there that wants it or has completely left. We have a situation, one of the homes that we had looked at and put one of the signs out front was an estate. The estate abandoned the home. The person living there had died. No one wanted the home. All of the beneficiaries of the estate have gone and don't even live in the area anymore. Yet we still have to go through this tremendous amount of hoops and jumping over hurdles and having all of these conferences for something that nobody wants. Let's really fix the problem. Let's expedite this as quickly as possible and get to fixing the houses and fixing the problems. Would Mr. Goodell yield for a minute? Mr. Goodell, would you yield?
Mr. Goodell, why do you rise?
Mr. Goodell, I just
I would
had
be
a
glad
asked
to
him to yield.
You want Mr. Walter to yield.
No, I want Mr. Goodell to
You
yield.
want Mr. Goodell to yield.
Would he ask if would not yield, but rise for some questions, I guess.
That would be yielding, true.
Yeah.
So now we've got it right. Mr. Goodell, do you yield?
I would.
Mr. Goodell, you were finishing up a thought. I thought maybe you had a few more minutes to talk, wanted a couple more minutes to finish that thought. Could you tell me where you were going with your last comments there?
Thank you, Mr. Walter. As you know, and I appreciate the opportunity to finish that thought, Mr. Walter. As you know, when people want to buy a house, they want to share in the American dream. They go to a bank. They ask a bank to lend them money so they can buy a house and live the American dream. And when they do that, they promise the bank they'll pay the bank back. They promise the bank they'll maintain the house. And if something goes wrong and they break all their promises, they don't maintain their own house, they don't pay the bank, and they walk from the property, what this bill does is say, we're going to punish the bank for having the audacity to help some people try to achieve the American dream. Shame on you, bank, because now we're going to make you pay. Not only are you losing your investment, but we're now going to add costs. And we add delay. And when we add delay, we eliminate any possibility.
Ms. Weinstein, why do you rise?
The time now to yield to a question? I'm not sure if it's
That would
Mr.
be-
Walter or Mr. Goodell.
It's Mr. Walter's time. Mr. Walter, do you yield?
Sure, I'd be happy to.
Absolutely.
I don't know if Mr. Goodell has finished extending his
Have
time.
you- It's not Mr. Goodell's time. So if Mr. Walter yields to you, you have the floor. Well, unfortunately, the gentleman who he gave you up.
Okay.
Let's put it that way. I don't know why,
I'm just being courteous to Ms.
but you
Weinstein.
have a second time coming, don't you, Mr. Goodell? So, right.
I'm not sure.
All right, so
do you
the
have
question-
anything further to yield as add as a question? But Mr. Walter, would you agree that under the current law, there is a duty for banks to maintain property at the time of that there's a judgment issued, a judgment foreclosure?
That there's a duty?
Yeah, under the law that we have, that there is a requirement for banks to maintain property when there may in fact be a tenant there, before there's the actual sale.
I think there's a duty for the bank to, I think there's a responsibility for the bank to maintain the asset. I think that would be in their interest, certainly in their interest to maintain it.
Yeah. So,
Certainly after the foreclosure, the judgment of foreclosure, yes.
right, after the judgment of foreclosure. So isn't it really true that all we're doing here is moving that time of the bank's requirement, the requirement on the banks to maintain the property to earlier in the process? Is that sort of cutting to the chase of what we're doing here? We might disagree as to whether that should exist, but the reality is we're just moving the time that the bank has that requirement to maintain if the property is abandoned and vacant to an earlier time in the foreclosure process.
But we're not giving the bank any other, privileges or responsibilities when it comes to the property. They can't put it up for sale at that time. They can't, rent it out. They have no other rights to the property if we move it up. If we're talking about after the judgment of foreclosure, they have additional rights. If we move the process up, they're getting all of the responsibilities and none of the rights.
But wouldn't you agree, though, at the time of the judgment, the foreclosure judgment. They're not the owners either at that time. It's just they don't have title. They're still waiting for the sale, and they still have that requirement to maintain the property under current law through that period of time to the sale, so that it isn't that much different. Clearly, it's an earlier period of time.
But it's enough of a difference, though, as we advance this time to the point where they're becoming responsible for a property, where they're not entitled, there's no foreclosure, there is the potential for increased liability, that there is that it's saved by the bell.
Thank you, Mr. Walter.
Yes, thank you.
Well, thank you. Mr. Morelli, another voice.
Thank you. I apologize for interrupting, but we need to have members of the Codes Committee in the Speaker's Conference Room. Mr. Lenthal is prepared. This is a real announcement this time, really codes in the Speaker's Conference Room.
Codes for Rio in the Speaker's Conference Room. Please go there immediately. Ms. Maliatakis.
Mr. Speaker,
On the bill, Ms. Maliatakis.